Okay, now we can go.
So before we started the class, I wanted to have everybody on here because we have an announcement that we wanted to make today. And Michael, could you roll the video for me, please?
Oh.
Yeah.
Hey there, Jennifer. Sid, one of the regional directors from RE/MAX headquarters here. And I just got to tell you how thrilled the region is for your success. And we are so excited to be able to award you with the 2021 Admin of the Year. We know that owners and agents cannot function without a very strong support system behind them.
Oh my God.
For 24 years, you have been doing this with a smile. And I can tell you those who nominated you for this position have said nothing but gleaming things about your commitment, about your value system, and everything that you bring to the table all day, every day. And for everybody involved, we cannot thank you enough. So again, from the region's perspective, congratulations on such a prestigious award. It could not go to a more deserving individual. And from Lori, Lisa, and the rest of your team, congratulations.
Here you go.
You're welcome.
Oh my God, it's so many right.
Congratulations,
Oh
Jennifer.
my gosh, thank you so
Here you go,
much.
Jennifer.
So Lisa, do you want to explain what you just gave her?
Well, it's the Administrator of the Year. So every year they have,
They is RE/MAX.
well, RE/MAX headquarters.
Right, not Whatcom County. This is the big
No,
boss
this
in Denver.
comes from Denver, Colorado, but they send out nomination forms for people to get nominated. And I've been nominating Jennifer for a really long time, but she got it this year. And so it's for the region. And the region is Washington, Oregon, Idaho, Montana, and Alaska. So she's Admin of the Year for the whole region.
Wow, congrats, Jen.
Thank you. Thank you so much, everybody.
Yeah.
Not a
Okay.
big deal.
Yeah, it is a big deal, but I just wanted to share it.
Wow.
That makes me cry.
And she
Right.
probably wondered why we were having her sit in on a gas and oil lease this morning.
I'm gonna go try my office now.
Thank you.
Thank you, everybody.
Thanks, Flower.
Congrats.
Okay. That
There's
is
a bunch of
exciting.
people in the comments commenting and saying congratulations, Jennifer, just so you know.
Yeah. We're proud of you, and we couldn't function without you and your hard work and dedication, and 24 years. It's pretty amazing. So, and Denver, Colorado, thanks to Lisa's nomination.
Thank
As-
you, everyone.
Yep, you're welcome. All right, let's switch gears here and get rolling. In lieu of our normal mastermind roundtable that we do every Thursday, I had invited special guests from Chicago Title, our go-to for all things escrow and title, and asked if they would give an explanation, a class. I want it to be participation. So if you've got questions, either virtually raise your hand, put them in the chat box. We'll kind of monitor that. But a lot of you were getting title reports, which congratulations for actually reading them. Because on there were oil leases, gas leases, and various kinds of things that were not going to be cleared with title. And we had buyers who were expressing concern. And I don't mean these were things out in the county. These might be things over in Eldridge. They're in the city of Bellingham. They're in the city of Linden. They're down in Anacortes. So number one, I hope we come away today with just kind of an overall explanation of what they are. And then if you have a client who insists that they be taken off of the title or gotten off of the title, and I know that's bad grammar, those are kind of the things that we asked to cover. But I love these classes with Chicago because you guys come up with such great questions. So with that, I am going to turn it over. We have Kirsten Hunt with us this morning, the amazing Kirsten. We have Jason York, and we have Jamie Concannon, and I think that was it from Chicago. But the three, Yep, these are the three that normally come and give the live classes to us. We're still Zooming, but it's great to see your faces again. And we really, really appreciate you guys taking time out of your busy schedule to come and help educate our crew. So with that, I'm going to mute and turn it over.
Thank
Very
you
cool.
so much for having us, Lori. We really appreciate it. I see the 3 title musketeers. That's great. The 3 amigos, that kind of thing is always good. But so we're really excited to do this. And it's a good learning experience for Jamie as well as myself. We're going to have Jason started off, talk a bit about mineral oil and gas, that kind of stuff. But also then to finish all that, we're also going to give a little bit of an update of things we're seeing within escrow and things that could, that like generally, right, that are kind of popping up and stuff that we just really want to, get out there and make sure we're all on the same page on everything. So anyway, without further ado, I'm going to send it on over to my favorite title brain, Jason York. I don't know if all of you know that he has now joined, he's in the title department. I think it was right around 2019, moved over to the title department. So if you haven't seen him, that's why. So you might see his name on your title report, but I'm going to pass it on over to you, Mr. Jason.
Very cool. Thank you, Kirsten. So yeah, just kind of wanted to start off by Michael's class description here says that a lot of brokers are dealing with mineral and gas leases and reservations and stuff like that. And I just kind of wanted to give an overview of what is that? What is it going to look like on your title commitment? And then let's finish it off with ways and methods to have those rates returned back to title and have those exceptions from that ownership removed from the title report. So different types of oil reservations, reservations. There's oil and gas, coal, mineral, and then we have leases and surface rights and rights of entry, extraction, exploration, and the varying degrees of those rights that are contained in those reservations will be reflected on our title commitment, and it'll show the reservation on the title commitment, but then it'll also kind of give a subparagraph as far as what else is being afforded to that. So let's start with oil and gas, probably the most common one. It's just usually a general reservation on a deed. Farmer A sells to farmer B, and he's going to reserve 50% of the oil, gas, and mineral rights contained in the land. So is that, within that type of a deed reservation, we just show it as a reservation contained in a deed. We don't really get into the specifics of, does that owner have the right to explore? So in that type of a situation, if there was a giant pool of oil or gas found underneath there, and they started pumping gas out of the ground or pumping crude oil out of the ground, they would have to share in that profit from the sale of that stuff. So general reservations, you're going to see those all over the place. It's not specific to a certain area. The coal reservations, everybody knows that Bellingham used to have an active coal mine in the Birchwood neighborhood area. And I'll read those reservations real quick, and what it's going to look like on your title commitment. A reservation by Bellingham Bay Improvement Company, a corporation, for all coal deposits located at a greater depth than 200 feet. So what does that mean for my buyer? Really, there's no surface rights. They can't really, move any of the fences or landscaping or the structure. They have the right to be mining for oil well below the surface of the earth. If there are any disruptions in the reservation, if there's any disruptions to the surface rights. So a sinking of the foundation or something like that. Bellingham Coal Mine was obligated to remedy those financially.
So
so-
Jason, I got a quick question here. And you maybe you're gonna cover this in a minute, so I may be getting ahead of myself. But what if Bellingham Bay Improvement Company is no longer in existence?
You're correct. They are no longer in existence. So they've folded up. Their shares have been dispersed to other entities. We don't have a record of that though, right? So if Bellingham Bay Improvement Company dissolves as a corporation, where does that interest go? If we don't have a recorded interest, like returning back to the property owner, we can't return those rights back to title. Does that kind of clarify a little bit?
It does, because I'm guessing that with a lot of these, and not just in Bellingham, I'm sure they've got them in Anacortes, Mount Vernon, and all over the Pacific Northwest. But that would be the first question. I mean, if that was established, I mean, sometimes they actually attach them to the title, and it was done in 1934, or whatever.
Exactly. A lot of these reservations are done on deeds from 1907. Who is going to find the heirs and devasees of those deceased individuals? And that's the function of an attorney. They're going to be able to hopefully bring an action in court. So we're going to talk about how to remedy and remove those and return those rights back to title.
Perfect.
Yeah.
One other quick question.
Sure.
You mentioned rights versus reservations. Can you just give a really quick definition of the difference between the two?
Surface rights. So that's what I'm trying to get at is do I have the right to walk onto your property and drill and explore? And if it's not expressly like stated, there's an assumption that it might be there. And so as a title insurer, if somebody exercises that right, we're not going to stand in the middle. Yeah. It's pretty vague, right? Am I being vague enough for you? A lot of these reservations didn't have methods for remedy. Like what happens if I have to drill and disrupt the surface of the land?
So is one stronger than the other legally, a right versus a reservation, or are they kind of mixed up between the two?
Synonymous, yeah.
Okay.
Yeah.
Okay, they're synonymous. Thank you. That's where I was getting gummed up.
There's the reservation of the right, so it's retained by the property owner that's selling, and then the rights are the thing that are reserved. When they don't reserve the right to explore, extract, and the surface rights, then it's kind of vague, right? Does that make sense? Like who's gonna recover our property owner or our insured if they have to move the garage out of the way to explore for coal or whatever the right that was removed or retained by that person. State of Washington, anytime you have a deed from the state of Washington to anyone, they are always 100% of the time going to reserve not only the oil, gas, mineral, coal, anything, excuse me, fossils, but they also reserve and grant to itself the right to drill, the right to explore, the right to extract, to build machinery to convey those mineral interests off. But at the very end, in all these reservations, the very last statement is sought to be full payment for all damages sustained by the owner by reason of entering upon said land. So if they do find that there is a significant a gold deposit in this former bed of the Nooksack or something like that, right? And they're going to grant mineral rights or what are those called? Mining claims to other people. That's a right that's already been reserved by the state of Washington. They can grant that mining claim to somebody, but they have to recover that property owners for their losses. And there's, yeah. Does that make sense to everybody?
So, Jace, I got a couple questions as well. So, just because we show this on, maybe one of these reservations or leases on a preliminary title, does that necessarily mean, or does that say definitively that there is oil or gas or coal or any other type of mineral that could be taken out of that, or that it's already there? Or is it just kind of like a blanket thing that people have put out there?
That's exactly right. There is no assertion that there is an actual claim or an active mining operation or an active oil producing property. So
because like my understanding of some of these things where you had these reservations that were done when Farmer A sold to Farmer B,
yep,
because they didn't know if there was anything there, but they didn't want to give away any proceeds that they could have recovered. So that's why you see these things. So sometimes it doesn't even apply because there's nothing there, or it's not economically feasible to remove it, correct?
for sure. Yep, 100%. Yep.
Okay.
And we've all heard about the mailbox millionaires out in the Dakotas and stuff like that. That's what those people were trying to retain, is if there is a significant pool of oil that is, discovered later down the road, they're going to get paid. Those people, they never had, it was their parents or their grandparents that reserved those rights, and then it's been passed down to them. Those oil companies have to find out, who do I need to write checks to when they do have productive wells.
And Jason, may I ask you a quick question? Because I think this is probably on everyone's mind. How often are you hearing that people actually try to extract here in town? Are you hearing that that's actually something that they're going for, that they're trying to do?
Natural gas was somewhat productive in certain pocket areas. I don't know of any that are going on right now.
Mhm.
There was a company, Rival Resources, that was going around and obtaining a bunch of oil gas leases with property owners, and we'll talk about that too.
Great.
So yeah, they're
Real quick, Jason, I
have been
think,
abandoned. Yeah,
I think one of the underlying things that, at least in Whatcom County, probably Skagit too, is how difficult it is to get a permit from the county. I mean, this is all good, but they are the ultimate arbiter, and you can be right, but they're the keys to the kingdom, and they say no a lot more than they say yes.
for sure. Yeah, there was a decent sized pool near our property that we have, and Rival Resources. It was easy for me to find an example because I just pulled up my old title report. But Rival Resources had collected, like, hey, we can actually extract natural gas out of the ground and it can be productive and we can sell it. So there's some stuff out there, but that was from 2001, 2002, and 2003. I don't think that they're continuing on anymore because of the probably the state environmental protection agencies and Whatcom County and Skagit County and Island, Snohomish, you name it. They have ultimate control over, can you put that drill bit in the ground and start exploring.
Also, one other point I wanted to clarify. You had mentioned about mining rights, like, or where it's 200 feet or below.
Yeah.
So were you saying, or are you saying that they can't come in and strip mine to get to that?
No.
It's they're literally, it's mine shafts and things like that.
Correct.
Yep. Okay.
Yep. So think about your fee simple title as an inverted pyramid. You own from the heavens above to the center of the earth when you own a plot of land. The four corners are pinned and it goes straight down to the center of the earth. You own all of those rights unless they've been reserved and unless they've been conveyed to other people. In this case, Bellingham Coal Mines, before they sold off any of the stuff over there, they reserved those rights for the coal. So yeah. Let's go over the McKay Land Company. I know that one's another really common one. There's a developer, real estate developer that have obtained a lot of those surface rights back in the late 70s and early 80s for pennies on the dollar. I don't think he even paid anything for them. But then he's, because he has the right to explore and extract, he has those surface rights. If you're going to put a commercial building on the property, you need to really obtain those rights back. So he knows he has something of value. He's willing to give those rights back to the property owner. And I believe the last time I ran across one, he does it for 7% of the assessed value of the land. So for instance, you've got Costco, and if their assessed value of the dirt in the raw is $1 million, he would take $70,000 payment to return those rights.
Is this the area that's kind of over by Bakerview, Cordata-ish?
Yeah. North Bellingham, by the airport, all the way over to Smith Road, Aldrich Road, the new, what is that? Cordata area, that whole area too. So yeah, but the kind of the sticky part that he hangs his hat on is if he extracts those, or if he exercises those rights, he gets to determine how much he pays to mitigate your losses. And it's pretty vague and unclear on how much he has to pay you, so, well, it's not my fault that you put a $5 million commercial building over the top of my my lease area or my rights to my surface rights. I need you to move that out of the way so I can drill for oil down there. It's a good play, man. He's very successful for a reason. He's so let's go over that and some of these oil and gas leases. Again, we have it'll show as a lease on title, and the rights to extract those things. It'll have surface rights retained in there as well, so for them to explore. Again, a lot of these were established in the 70s, 80s, 90s, all the way up until the early 2000s. Not a lot of them are active. I don't know of very many at all, if any. So we can take what's called an affidavit of non-development. And we were talking about how to clear some of these issues. And they're is it I don't know. Is it a good idea to have these things removed before your buyer takes title, or is it, a good sound practice for you to just say, well, there's really, there's no active operation, nobody's using that lease, it's kind of technically abandoned. So, it's up to you and your client at that point on, do you want to make this a hardline item to object to this remaining on title? And if that's the case, then, you write an objection letter and say, we don't want to have paragraph number 4 on the title commitment to show on the owner's policy. And you put that back on the seller and their listing agent to return those rights back to the property. Has everybody worked through an objection before? Not a lot of people have, I'm sure. Yeah.
What's the cost to do the affidavit of non-development to remove that?
Nothing.
Zero.
No.
So is it a recordable item, or is it just something that we have?
Sometimes we'll record them. Sometimes we'll just keep it in our file. And it's the seller or the owner is making an affidavit saying that they are the current owner and they have full possession and full use of the land and full knowledge of what's going on out there. They also know that the lease term has expired. and that the development set forth in the lease has not taken place. So there's no like, drilling or collecting or anything like that. And they haven't been paid any money. That's the key too. Some of these guys were, it was something like $200 a year to keep these leases active. And so they would just send a $200 check to the taxpayer, recorded on title, and perfect their lease for another 10 years. And we don't know if any of those things have happened, if that money has changed hands. So we still show it until we have some sort of an affidavit to remove it.
And so that can remove leases, but that doesn't remove like mineral rights and things like that.
Correct. Yeah. What do we need to return mineral rights back to the property, or coal reservations, or those types of things? We need a deed from the person that reserved those rights, a quitclaim deed, something like that. If we can't get a deed from them or their heirs, then it's really important that the stuff get returned back to the property. For example, I plan on having a gravel pit on this property. I can't put these minerals into a container and sell them to somebody else and ship them off of the property without having, stroked a check to this other person that's retained 50% of those profits. So getting those rights returned, it's either by deed or by a quiet title action. And that's a method of serving the known property owners or the known record holders of those interests. And if they can't be served individually, a public service type of a publication in the paper saying, hey, anybody, if you think you have an interest in these mineral rights that were reserved in 1931, show up to court on this date. Otherwise, you will be your interest will be quieted.
So if someone was taking a listing, they order a preliminary title, they take a look and they see something like that, and they want to be proactive and get started on maybe the removal of that. Is that something you would help them with, number one, or do they have to get an attorney? And the second question is about how long, let's say we have to go through quiet title, that's probably going to be the easiest. What kind of a time frame are we looking at to get that accomplished?
It depends on if people are able to be served and they are able to show. If it has to be a public service or a service by notification or publication in the Bellingham Herald and the Linden Tribune and the Ferndale Record Journal, then I think they've got like 90 days to respond.
Oh.
So might take some time.
Okay. Do you see many people going through that, or do most people just, it's been my experience in the past that most people, we just say, they've been there for years. If it's a concern, talk to your title officer, but the odds of getting them removed prior to closing are pretty slim. Right now, we're in a market where the buyers are letting things go. If that market shifts, it might change the outlook on that. But
right.
Do look at your title report or your preliminary title report if you've got one, as either the listing or the selling broker, and see if that's in there, because especially if you've got a first-time buyer or somebody from out of area that's not familiar, that is going to raise a red flag with them.
And you don't want it to be the red flag that's raised as a buyer's agent or a selling agent 3 days before closing, when they finally review all these things. Okay, I'm going to drill down and really understand what I'm buying here. And hey, what are these? Can we get them removed? It's kind of, bad practice to go, yeah, dude, that ship sailed a while ago. You needed to say something. When I emailed you, remember when I said, hey, your title review contingency is about to expire. Do you have any questions?
Well, because I've had brokers tell me they were successful in getting these removed prior to closing. Mm-hmm. And so I'm thinking, an average contract is 45 days. Can it really be accomplished in that short of a time frame?
The oil gas leases, yes. Easy peasy. The rates, but then also, what if it's somebody like I'm trying to Marv Van Mersbergen or something like that. Like, yeah, we all know who his family members are. We can get a quitclaim deed from them if they, if he reserved them in 1984 on a deed. We can get those rates returned pretty easily. So,
Okay.
yeah.
All right.
Any other questions? I don't see anything on the chat, other than like we could upload a preliminary title. And I'd be happy to craft a bunch of different versions of the oil gas leases, the reservations, and then those sub paragraphs that contain like,
Well,
hey, this one has rates.
Yeah,
of entry.
let's pull a few of them up, Jason, and take a look at them, because we've got brokers on the call that may have seen them and then they may not have. So let's show us what. So if they're not cleared, just for clarification, they are going to run with the land, correct?
Correct.
Right?
Yep.
also
I don't have
probably-
anything pulled up like in front of me where I could easily share that with everybody.
I could
Oh, okay.
probably do some snipping things and do that on a title report and email that to you, Lori, so that you can distribute to RE/MAX so that they can see it along with
yeah.
the affidavit that Jason's talking about
Yeah.
too.
Yeah.
So
No
that
problem.
they can see what that looks like, so that we make sure that we have all that, so you guys can read it.
Yeah, I misunderstood. I thought he said he had them there. So it's
No, yeah, totally.
I've got the codes.
And if there aren't any other questions on the oil, mineral, gas stuff, I do have a question for you, Jason. You're in the title trenches. You see all the different title reports. You work with a lot of agents to help clear stuff. What is it looking like for anything that you would like any issues that you keep seeing arise, anything that has been something that's been popping up a lot lately, or that you would like to make sure that the agents know?
Yeah. The one that I'm working through on my desk right now, the broker, they included for the legal description attachment to the purchase and sale agreement, they included like the full property profile, which includes the deed. It included a community property agreement, and all this stuff is all signed by the buyer and the seller. And I'm going, this is not really part of your contract. So I think it would be really helpful for us and you guys too to identify where is the legal description on this deed. I don't need to include all the other stuff. I don't need to include the plat map. I don't need to include anything else. Those are all, helpful in identifying certain characteristics of the property and making sure that all that stuff's good. But the legal description is really the only thing we need in a contract. And then also
where might that be located, just so that to make it clear? I know that there's some newer agents on here and everything
Sure.
too. If you were to describe on the deed, where would the legal description be located? How would it maybe start?
It'll say the following described real property situate in the county of Whatcom described as follows, and then a colon, and then there will be the legal description. Lot 5, block 267, Ferndale add to Whatcom County, whatever the plat is. Or the southeast quarter of the southwest quarter, section township range. So, yeah.
So Jace, we do have a couple questions.
Sure.
Tammy McKenzie was asking about a listing that they have
Looks like
upcoming.
Lori answered that one.
Oh, did she?
Mhm.
Oh, you could actually upload the preliminary title report. Okay.
I think Rick Meyer, he said, Jason, can you touch on life estate? I've had a few of these recently.
I'm working through one right now where the sellers reserved a life estate. They transferred the property to their 2 children, kind of an early estate distribution. And people do that for a number of reasons. They don't want DSHS to attach to their family home. They know that they're going to probably need assistance in their final days. And so they go to an estate planning attorney and they say, hey, deed it off to your kids early, reserve yourself a life estate. So what do we need to remove those? We need a death certificate, or they need to join on the deed. In this case, I've got mom passed away, and the other person, who was her second husband, he's got some issues. He's over in Eastern Washington. He has had a stroke. He is unable to manage his own affairs. Can we take a signature on a deed from him? Probably not. So we reach out to his medical power of attorney, and then his medical power of attorney is like, yeah, I'll sign it for some money. So you never know what you're going to encounter when we have to remove these things. Is that right? For him to maintain that life estate, he needs to reside in the property. But as title insurers, we can't say and make a determination that he's not going to recover from his stroke and he's not going to want to return back to the property. So let's say 3 months, he tries an experimental drug and he is completely well and he wants to move back into that house. Well, we've closed. So he's trying to reassert his life estate and his right to reside in that property. And we've got to get out the checkbook and help him out and find a new place to live. We don't like to do that very often. So cover life estate's pretty good. Yeah.
Yeah, I think one more thing, because I know that you and I have talked about it recently, is maybe touch on the fact about people taking title or moving things into LLCs, trusts.
Thank you. Yeah.
Corporations, anything along those lines, and then removing that and what that looks like. We've been seeing some of that pop up. So let's just touch on that for a minute.
So let's boil this down and the importance of not just opening preliminary title at the time of listing, but also getting a property profile. And our customer service department is well trained. They're good, thorough reviewers of these potential roadblocks and stumbling blocks for clearing title, right? So let's say I have Jason York LLC, and I forgot to go to an attorney and draft an operating agreement, and I never even established a bank account. And now I go to Blake and I'm like, hey, Blake, you want to list my property? And he's like, yeah, no problem, dude. And I go, oh, I'm going to be getting proceeds in the name of Jason York LLC. I got to get that out of there. So I draft and record a quitclaim deed, removing title out of the LLC. The title officer is likely going to backvest to that and not recognize the quitclaim deed. We're just going to say, hey, we never reviewed the operating agreement for the LLC. We can't rely on this self-drafted, do-it-yourself quitclaim deed that Jason recorded himself. Now, had I gone to my attorney, there's a probability that we would likely rely on that, or we'd give a call. Hey, Mark Lackey, does this guy have manager authority? And he would email us over the operating agreement or the LLC docs. Does that kind of make sense? So
how often are we seeing it where people will do an LLC and want to either purchase it or sell it in their LLC and have zero operating agreements? Because that's really where it gets a little sticky icky.
Yeah, I'd say, 1 out of 20 people don't really, oh, whoops, I needed to do that. And it's not that big of a deal, right? For title, we're more than happy to accept an affidavit saying, hey, I don't have an operating agreement. I never went to an attorney. And it's me and my wife. It's a 2-member LLC. And then we can look at what is filed with the Secretary of State and go, okay, those 2 things kind of line up. We're comfortable moving forward. But don't make assumptions. Get it all, get the preliminary title opened, and make sure that those issues are not going to be roadblocks from closing.
And I think just to kind of clarify for everyone, so if someone is holding title in an LLC, a corporation, anything like that, a trust,
Yeah.
in a state too, that the seller, when they go to sell, actually have to have a bank account open for that LLC, trust, corporation, because the proceeds can't go, like, let's say Lori Reese has an LLC, Sunshine Flowers Love LLC. We're going to call her a little hippy dippy today. And she goes to sell that property, but she doesn't have a bank account. We can't make the check out just to Lori Reese, even though she's the only member on it. So just keep that kind of stuff in mind for when, estates too. So estates, LLCs, trusts, corporations, that kind of stuff. So keep all of that in mind.
So I have a question that I get a lot. So when somebody is, usually it's when they're selling a property, and let's say it's in an estate and there's 5 heirs, they're scattered across the country. The heirs get together and they say, Susie, daughter number 1, is going to sign on all of our behalf. Everything can run through her. And the question inevitably comes to me, do I need all 5 signatures on there? How deep do you look into wills, all of those things? Or let's say it's an LLC and it's a 5-member LLC, and they just tell you that Susie is designated to sign on all of our behalf. What documents are you going to need to verify that, and do they have to be recorded?
No, they don't need to be recorded, but we just need evidence by, let's say it's that 5-member LLC, and we're going to nominate Kirsten to manage this whole transaction. We need a special meeting, or what is that called?
Yeah, Lisa knows.
Oh man, I'm drawing a blank. But it basically is all of us, the other 5 members or the other 4 members, saying we all agree we want Kirsten to sign everything. It's kind of like a power of attorney, right?
So that can be done after the fact. So they've got an LLC, they've got an operating agreement. In the operating agreement, they don't designate Susie as the authorized signer, but then later on when they go to sell, they want Susie to take care of it. So they can then just go do special minutes or special whatever and have a meeting and appoint her. That doesn't need to be recorded?
Resolution by the directors, or resolution by a corporate resolution or a company.
Okay, and so
resolution.
no, that wouldn't be recorded, but as a listing broker, a selling broker, I think I would want to see a copy of that.
You want to submit that to title early so that we can review it and we can go, yep, we're good with this, or no, this isn't going to work. I don't have this other person. Some of these LLCs and corporations are layers, right? You've got a trust that manages this, but we can't have this person sign. So we've got to review it all. We've got to look at it all, and it all has to make sense. We can't be like, not quite. In an estate situation, let's say mom passes away. We have mom and dad on title. Dad passed away in 2007, and then mom finally passed away, and there's 5 kids. And they all agree that Susie is going to manage the whole thing, right? She's going to sign everything, your listing paperwork, all that preliminary stuff. If you have something from the siblings, the will, or whatever that says, yeah, we want Susie to manage everything, I think for your guys' purposes, you could take just that signature from Susie. Title, when we have the deed executed, we're going to have all potential heirs sign off. Excuse me. If that will nominates Susie as an executor or a personal representative of the estate, those are court appointed positions. So the only way that we can rely on just Susie's signature to pass title out of the estate is if the court verifies that this is mom's last will. She was the surviving heir at law to dad's estate. No other heirs have come up and said anything. Nobody else has produced another document saying, hey, wait a minute, I had a later version of the will that says Susie gets nothing and I get everything. So if we don't have any opportunity for something like that to happen, then we have to have everybody that is a potential heir sign off on the deed. Does that make sense? but we don't have to have them sign all the escrow documents and everything like that. But
Oh, okay.
you know, it's just that disbursement instructions, settlement statement, and the deed.
So I'm gonna run another one by you that I get all the time. So
Yeah.
there's a lot of investor purchasing going on in the marketplace right now. And so the investor comes to me and says, hey, I want to make an offer. The offer gets accepted and they say, oh, and by the way, the buyer is going to be ABC LLC. And I go, okay, great. So we put it in there in ABC LLC. And then they say, oh yeah, we're going to need a little extra time because I haven't set it up yet.
Right.
Would you explain the legal ramifications of why that's not a good idea? It happens a lot. You don't, what I basically say is you don't even have a legal entity if it hasn't even been set up, correct?
Correct. They are not an entity capable of holding title in the state of Washington or wherever we're transacting. If they don't have their certificate of formation with the Secretary of State. The Secretary of State will say, yep, you are legally now authorized to operate under this entity name. And until we get that, we can't really put title in that name because the real problem is going to be when they go to sell it. And we say, you don't have the authority to sign anything legally, and you don't have the authority to dispose of the property. So then we have a kind of a title claim issue at that point.
Okay.
Yeah. So yeah, make sure that they, you know, you could do like a Form 34. The buyer is going to be XYZ LLC or something like that. Or you can, after they've got their operating agreement filed and their articles of incorporation or whatever they're going to do with the Secretary of State, their certificate of formation, then you can do that buyer to be amended as follows.
Okay.
No, I think as agents though, we need to know that and then put and/or signs on a contract.
Absolutely. Yep. And maybe an explanation to the listing agent as to why we're doing and/or assigns.
Yeah,
We're
of
not
course.
flipping this contract to another investor or anything like that. We just, you know, this is a fourplex. We haven't formed our LLC yet. We're waiting for that stuff, and our legal counsel is working on it. Give us 2 weeks and
Or if they're gonna wholesale the property.
right.
Seen a lot of that going on.
Yeah.
So one thing to keep in mind too, that I've been seeing pop up a lot is when you're adding someone to title or changing who's going to be on title, whether it's the LLC or changing entities at the last minute, that can create a bit more work as far as especially adding someone to title. You know, we search the person's names that are going to be on title to see if there's any judgments or anything that attach. Also, like we've been seeing stuff where it's like the day before closing, we get this. And, you know, possible things that might have to get re-signed. We've got possible docs that have to get redrawn. So really keep that in mind when it comes down to the crunch time of adding people to the contract.
Yeah.
Okay. Well, thank you so much, Jason. I'm going to just talk a little bit about some of the things that we're seeing on the escrow side of things that have been popping up. And Jason, you're more than welcome to stay, or if you'd like, you're more than welcome to go. I know you guys are a couple men down today, so thank you so much for coming on.
Yeah, thank you guys.
Looks like Sean Jeffrey had a question for you, Jason.
Oh, sure.
Is that the one where the oil gas can show up as leases or as reservations and then different removal processes? I don't know. Did we already cover that one?
Yeah.
Yeah.
Yeah,
Okay.
we did.
Yeah.
So if you want to reach out to Sean, that would be awesome, Jason.
Sure, I'll email him that affidavit of non-development and
Cool.
a couple of different sample paragraphs. Thank you
Cool.
again, everybody.
Take care of that. Okay.
Yeah. Awesome.
Sounds good. Thanks. So just a couple things that I have been kind of chatting with our escrow department on things that have been going on. And this isn't a RE/MAX thing. This is just collective, you know, we see all the contracts, right? And a couple different things I wanted to kind of talk to you guys about that we're obviously seeing, you know, there's barely any inventory, right? I mean, Lori, you say that one. So multiple offers and wanting to make those offers look so good, right? So cash coming out of the woodwork, like who knew there was so much cash hiding around here? and kind of quick closings and what the realities of that look like, right? So different things that we're seeing and that we just want to make sure if you guys are trying to do quick closes, what that really should look like. And here's kind of your tips to make it smooth, right? One is, I know that we have a couple different counties on here, so I'm just going to talk in a very brief thing there. Check in with your escrow team of who it's supposed to be with. The contract is to see how long they need to close. Without looking at the title, we don't, there could be things that pop up on title that are not necessarily things that can make it a quick close. So, like what we just talked about. Checking in with your escrow officer, see what time frame they need, and then really count for a couple days of back and forth time, offer review time and stuff like that. Right now in our office, so in the Bellingham office, we are asking for 2 weeks or sooner. I know that some people don't like the or sooner, but for us, that kind of gives us a little hint. But we will do everything we can to try to get it closed sooner if we can. But that 2 weeks time period, we have to do title reports, wait for payoffs, buyer seller questionnaire. So different things to keep that on track to get there. Earnest money would need to be wired in on those transactions because we have what's called the good funds law. Jamie, you want to discuss that a little bit about what good funds law is and why we ask for wires on short closings?
So good funds are considered funds that are available within a specific time frame. So same day funds, the only, per Washington State now, the only funds that are considered good on the same day would be a wire. And so an electronic wire is not a, of course, I just lost the acronym.
Was that ACH? Is that what you're
Yes,
talking
it's not
about?
an ACH. Okay. We've had instances where clients have gone into the bank and asked for a wire and the bank will send an ACH. Our system is set up to reject those. The problem with ACH, and this is also real common with Canadian banks, they'll talk their client into doing an ACH instead of an electronic wire. The problem with ACHs is that money can be pulled back out of the account up to 30 days later. So on a quick close, you could have somebody send an ACH and the transaction closes, and then that purchaser could in reality pull those purchase funds back in that
And
next
so
30 days.
Just so you guys are aware, we don't charge for wires. Most banks will charge for outgoing wire fees or anything along those lines. We don't charge for incoming wire fees. So just kind of keep that in mind. So wires, and we will be telling clients, we will be telling agents, and then they don't listen to us. Like we get the contract and we're like, hey, it needs to be a wire for earnest money. And they're not listening. We will, not you guys, but it could be the other side of your transaction. If you are getting in a purchase and sale for your listing and it is marked check or cashier's check, please make it be a wire and state it on there. That way it'll bring the attention to the actual client to make sure that happens. We're also seeing that as far as like non-refundable earnest money and things done for give to sellers or what have you, make it available to the seller. That also would need to be a wire because that is becoming a problem where, people will put that in their contract and then give us a personal check. And we're like, we have to wait for the check to clear. A check can take up to 14 days to clear. So depending on where that's at. So just keep that in mind.
A cashier's check is good within 24 hours. So if you bring a cashier's check in the day prior to closing, prior to 3 p.m., those are considered good funds the next day.
So I'm thinking earnest money along the lines of like more of like an earnest money thing, right? So
yep, but I mean you can bring in a cashier's check as well for if it's a 5-day close or for us a 2-week close.
Yeah.
Personal checks Also, if they're using the mobile earnest money deposit platform, that is the same. That is just a personal check. It's just an alternative way to provide us with that personal check. So it does fall under the same
Category as a
set of,
personal check.
yeah, where there's that 10 to 14 day or 10 business day wait
Yeah.
period.
So, so definitely, and then title, like different things that can pop up on title and different payoffs that we might need to get. If there's anything federal, government wise, DSHS, federal tax liens, anything like that, minimum, you're probably looking at like a 6-week close minimum. It takes us a while to get those payoffs back. So how to help us is for your clients to make sure that they do the start in here, which is going to be that buyer or seller questionnaire. We need all of that information back in order to help us with our closings, right? To help us do the escrow process. It will help tell us what documents might be needed, different things we need to know. Also to consider, are your clients living out of state? Is anyone out of the area? What does that look like? On a cash transaction, we can have them do like a DocuSign for their docs for the buyer, right? Not the seller. The seller has to be notarized for the deed. So keep that in mind too. And especially if there's multiple people all over, that can be a thing. So just different things there that are helpful for us. Letting us know if your clients are going out of town too. That's always been a thing. Jamie, can you think of any other things that would help expedite escrow?
The big thing is we know that there's instances where your clients don't want their information disclosed on the purchase and sale agreement, which is totally fine if you send us over a signed purchase and sale agreement with no information as to contact information for your client. But please include it in the body of the email, or if we're picking up the purchase and sale, just have it as a sticky note, just so that we do have that ability to reach out to them as soon as possible and get starting here initiated right away. Or if we have any questions, instead of having to go to you and then you getting back to us, it just causes delays.
And making sure that you guys are reading the title reports up front. We are seeing, with the mortgage forbearances, if there's a payoff needed for those, they are taking longer than a regular mortgage payoff. Just so you guys are aware, those do take longer to get. And a lot of times those aren't being disclosed to us that someone has that. So it's when we go to order that payoff that we find out. Contracts that say that they need a 3 to 4 day close, something like that, we're not able to make that happen these days. And especially with payoffs involved. So, when we do pick up the phone and let you guys know that, it's not that we're trying to be a pain in the rear end. It's just that that's not that realistic these days.
It's the same thing that we're running into in our regular day-to-day lives. If something's are being delayed and it's COVID. So, whether it's people working from home, not having enough people working to get the stuff done. And a lot of times we won't find out about it until it's a 24-hour payoff turns into a 5-day payoff. So.
Okay, so I was going to say we're bumping up against 11, so I'm going to wrap up here pretty quickly. One side note, because I know we have people from all of our offices on this call, Gateway and Whatcom. We are so fortunate here in Whatcom County to have probably the best Chicago title, in my opinion, in the entire state. They are more than happy to do courtesy signings for those of you in Skagit, because I did just send an email out yesterday that the Chicago in Mount Vernon is no longer accepting checks for earnest money, only on vacant land transactions. They say
I will touch on that too.
Yeah. They said there's been too much fraud, and I just said I completely understand, but you need to communicate these changes. And a lot of people, anyway, don't mix up the two. The Chicago title that we have on the call today are Whatcom people, which they can do courtesy signings in Skagit, wherever. So don't mix up the two. This is not the Chicago I just sent the email out about.
We can actually do the Skagit County escrows here. And as of right now, we haven't heard, when that was said to me by one of your agents of this is what's going on, I was like, what? This sounds like fraud.
I called yesterday.
Right.
Nope, I called yesterday and I talked to somebody named Kim, and she confirmed it.
Oh yeah, we
Um,
talk straight to the manager of the county. So
Yeah.
one thing I wouldn't be surprised too, and I can call and verify and email you back, is that I wouldn't be surprised if it's also Snohomish County because they're
Right.
managed by the same. So as of right now, I'm not hearing that in other operations. I think Jamie and I, when we heard that, we were like, how is it more fraud with vacant land? But obviously that's out of our hands, right? So if there is an underwriting thing or someone got their hand smacked in a claim, that's going to be something that, they might enforce in all the other ones. But as of right now, we're not seeing that in Whatcom Island County or San Juan. And actually, when I talked to Addie about it, she's like, that's so strange. And she reached out. So anyway, I guess that there is something, but I don't know. We haven't been told that we need to do that yet. So keep that in mind.
Okay.
That's
That
not-
was really what I wanted to cover. I just wanted to clarify because, I mean, it's apples and oranges, day and night difference between them. And I meant to say you're probably right about Snohomish. So I guess the moral of the story is if you're dealing with a title company that maybe you haven't used before or haven't used in a while, it's always a good idea these days to wire. Just make sure that your client gets in touch with the title company directly for wiring instructions. Do not be the one to
before you
deliver
wire.
those wiring instructions. That is not our job. Matter of fact, I don't think we can. I mean, we don't have the wiring instructions. I just did a wire down to Seattle on a closing, and I actually had to call the Chicago Title in downtown Seattle to confirm in advance I was going to be sending the wire, and then I had to call after I'd sent the wire. There was quite an elaborate process, which is awesome to help
Yeah.
protect our clients.
Yeah,
we won't send them out to you to send to your client, just
Ever.
to protect you as well as
Absolutely,
to protect your client.
we
100%.
can't speak for other title companies that aren't part of the Fidelity family. But for us, we will never do that because more than likely where the hacking point can happen is between agent sending it off to client or anything along those lines. So once it's out of our secure portal sent somewhere, that's where the hacking point can be. And they're looking for buyers, sellers, all that kind of stuff to see what's going on.
Well, and it has happened. We had a not so distant case of somebody who lost $103,000 through a bogus wire request that looked very, very valid. So always look at your return email. So
And
all
no
right,
one's on the hook for that. Like, you can't get that back.
no, you can't get that back. I'm going to wrap up. Thank you, Chicago Title, Jason, Jamie, Kirsten. We love you guys. Really appreciate you joining us today. And these should be your go-to when you've got questions on things. Send them your next escrow. And and have a great day, everyone. We appreciate it. Thanks
Thanks
for
for
joining
having
us.
us.
Okay.
Thank you all.
Bye.
Bye-bye.
Bye.